Before we begin, I'd like to thank all of you for using all of our social media platforms to communicate with us. And another reminder that we are tweeting live today. Use the hashtag VOA ICC Africa Leaders. And if you haven't yet, please follow us at VOA Shaka. And speaking of, let's go to a tweet from Wako Joel, who tweets, yes, the ICC lacked credible evidence to incriminate William Ruto. Witnesses became coy or may have been silenced. We have another tweet from Emmanuel Kachele, who tweets, dismissal of charges against Ruto is a key to stabilizing Kenyan government, but disappointing to the victims. Now to a comment from Facebook fan Guma Buma Michael from Leuven, Belgium, who writes, the ICC was caught between two hard rocks, faced with threats by most of Africa's quasi-dictators to pull out of its confines. The ICC cowed down, much to the chagrin of those whose relatives were innocently butchered in one of Africa's worst ever post-election violence. Very absurd. Well, Shaka and guest, a very wide range of opinions here. What's your take?
Very interesting. In fact, I might also add, although of course someone alluded to it, what in fact happens if the African governments pull out of the ICC? Does this mean, for example, Kenneth, that no African leader can in fact be accountable to anybody for that matter?
Thanks, Shaka. First of all, like I pointed out earlier on, the ICC treaty, the Rome Treaty, is a codification of much of customary international that has been going on. Now, there are two fundamental principles in customary international law. What we call state immunity pertaining to a head of state. There is, first of all, a personal immunity of a president when he's a sitting president. When he's no longer a sitting president, the immunity does not end. It continues but becomes functional immunity to the extent that the functions that he performed whilst in office, he cannot be held accountable for that. Now, the concept of state immunity does not sit by itself and is not absolute. In international law, there's what is known as omens, obligations of states, and iuscogens. Now, iuscogens, these are norms from which you cannot derogate. Whether you've got immunity does not mean you can go around with impunity to just break the law. And that's really the thrust of international criminal justice system.
But you can actually do that if you figure out a way of becoming a presidential monarch. Or a life president, for that matter.
Yeah, but under the Rome Treaty, the innovation that has come through under the Rome Treaty to depart from customary international is that there is no immunity. Immunity is waived. Whether you're a sitting president or not, you can be prosecuted. That position is not available under customary international. It's an innovation under treaty law, the Rome Treaty. Therefore, a sitting president can be prosecuted. Even worse, for example, in the case of Kenya, if you look at the Kenyan constitution, the vice president of Kenya does not enjoy immunity. It's the president who enjoys immunity. So he can be prosecuted even in Kenya itself if there is sufficient evidence. Now, the question is what will happen if these guys, African governments were to pull out? It's not only African government, including Europeans government. Under universal jurisdiction, you can prosecute certain crimes, for example, slavery, war crimes. Whoever committed a crime anywhere in the world can be prosecuted in any country whatsoever, regardless of where the crime was. For example, he's an American, he can be prosecuted in Kenya, Nairobi, for war crimes under international customary law. There is provision for that.
There is provision for that?
Under customary international
Except, of course, that the Americans have Article 98.
There have been a lot of scholars, pundits, who've argued against the concept of universal jurisdiction, but even these arguments are not very persuasive. It's well-established and trite reasoning in customary international law that the concept of universal jurisdiction entitles every state whatsoever to prosecute for those fundamental crimes which are committed by anybody anywhere in the world.
Very interesting. Ayen, what more do you have? What more reaction do you have from the audience, please?
Thank you, Shaka. Let's go to another comment from a Facebook fan, Martin Nyalusi from Tanzania, who writes, I think the ICC ruling is correct, and this shows a way of avoiding and scaling down neocolonialism. Africa should remain as Africa and not puppetism. And our last Facebook comment comes from Tumusegi Julius, who writes, I think the ICC was afraid to tamper with the prevailing peace in Kenya, and not that the prosecution had a case. Well, again, Shaka, a couple of interesting points made. Your thoughts?
Very interesting indeed. Nyeka, your reaction?
First of all, I believe that the decision of the ICC, to drop the case in Kenya is an expression of a political defeat, because we know that the ICC, even though the Kenyans themselves, they found a way to try and resolve the issue, the ICC was still adamant to continue to prosecute the president, the vice president, and other defendants in the Kenyan case. Now that the leaders have used their political power in order to rally many in Africa and in the world around the case, and then the ICC did not have any other opportunity but to drop the case. So it's a political defeat for the ICC. Now, like Kenneth said, I believe that this is what I want to see in Kenya, that the President Kenyatta really tries to put together a framework, for internal justice, for an endogenous judicial process, so that the pain of the victims, can be relieved. So this is what I really believe, and if it does so, then we have a reason to hope that Africans are mature enough, to deal with the internal issues, without the interference of the International Criminal Court, which is seen by many, like me, as an instrument of neocolonialism, because it is used by some powers in the West in order to either threaten some leaders or to have their way in our internal affairs in Africa.
We should point out, by the way, that in the Kenyan particular case, the Kenyan government had, in fact, an option of taking care of that business.
Yeah,
they simply couldn't do it. They decided to send it to The Hague because, according to William Ruto, he thought, in fact, the United Nations would probably take 100 years before it revisits that case, and by then he would be gone. Well, thanks, Ayen, for bringing us this week's audience reaction.
It's a pleasure, and that does it for today's social media segment. Just a reminder that we appreciate all the feedback, whether it's in social media form or using other means to communicate to us. Please keep them coming. And if you're a new fan, drop us a line at africatv@voanews.com. Once again, our email address is africatv@voanews.com. Or post your comment on our Facebook page. Enter the keywords Straight Talk Africa. Be sure to visit us online at voaafrica.com, or you can join our YouTube channel. Sign up to VOA TV to Africa and follow us on Twitter at VOA Shaka. A reminder that the show is streaming live every Wednesday. Go to VOA Straight Talk Africa TV program page on our website, or simply watch us live on your mobile device. Just download the VOA mobile app.